and the American Constitutional Society, the Federal Society, I believe to have somewhat not clearly exactly the same views on many things as organizations. But it is very important not to lose sight of the fact that our disagreement is placed within a framework of shared commitments. And one of the most central of those commitments is to the First Amendment, to the freedom of thought and expression. And the fact that ACS and TEDSOC are joining together to sponsor this event, I think, testifies to those two organizations' commitment to this shared American value. It's also a good time for us to be having the event because in a little bit over 2 weeks, it will be the 100th anniversary of Abrams against the United States. Abrams was a federal criminal prosecution of 5 Russian immigrants in the United States who held anarchist or communist political views and who had been charged with or convicted of violating the seditious speech provisions of the Espionage Act of 1917. It was no surprise that the Supreme Court affirmed the convictions. What was surprising was that there was a dissent. Justice Oliver Wendell Holmes voted dissent, joined by Justice Louis Brandeis, in which Holmes really, in many ways, kicked off modern First Amendment thinking. And although First Amendment law got a little more complicated than when Holmes was writing, he said something that I think remains central to First Amendment thought. The best test of truth is the power of a thought to make its way to be persuasive in the marketplace. And the only safe ground on which we can pursue political and social goals is truth. And that, I think, remains a bedrock idea in American constitutional thinking. I also want to thank Malin Glessman, the program coordinator for the First Amendment Clinic. On an almost daily basis, Malin's great work makes me think about the fact that I get to do all the fun stuff, and she has to do all the not fun stuff, which she does beautifully, and thank you, Malin, for arranging this today. Let me introduce our speakers. The role of posing questions will be played by our own Nicole Ligon. Nicole is a grad of the Duke Law School. She then went to a very distinguished firm in New York called Cahill, Gordon, and Reindel, where she practiced First Amendment law with a very distinguished mentor. Nicole then came back to Duke and is a supervising attorney of the clinic, where she is doing fabulous work. Our guest speaker, well, let me begin by explaining our guest speaker's status by telling you about a personal experience. A few months ago, I was preparing a paper. And in order to prepare the paper, I read the preface to a book by Judge John Noonan, who's now deceased, but was a distinguished member of the Ninth Circuit and legal scholar. And in the preface to this book, Judge Noonan talks about the role of individual lawyers, that lawyers can make a difference. And he says, in the process of saying that that's one of the things I'm trying to communicate, quote, "In a close case, I have no doubt that a lawyer can make a difference." And then he lists 3 lawyers, and the first name he lists is a Floyd Abrams in a free speech case. Judge Noonan didn't think he needed to explain who Floyd Abrams is or his connection to the First Amendment, and that's because if you have much interest in the First Amendment, you know who Floyd Abrams is. He is senior counsel presently in the litigation practice group at Cahill in New York, at least since the great Pentagon Papers case in 1971. His name has been linked closely with First Amendment thought and First Amendment advocacy, and for a staunch and brilliant defense of First Amendment values. Senator Daniel Patrick Moynihan, not himself an insignificant figure, once called Mr. Abrams the most significant First Amendment lawyer of our age. It would be impossible for me to overstate the role he's played, and it would spend too much time to single-spaced, I printed out a highly condensed summary of his accomplishments. I won't try even to give you more than just the barest idea. He's represented the Times, ABC, NBC, CBS, CNN, Time Magazine, Business Week, The Nation, Reader's Digest, Hearst, the AIG Group, Standard & Poor's, the Brooklyn Museum of Art, Munich Hodenberg, the National Public Radio, and on and on. He's a member of the prestigious American Academy of Arts and Sciences and has served as chair of various distinguished and important committees in government and our profession. The list of his prizes and awards goes on and on. He himself has taught at Yale and Columbia Law Schools and at the Columbia Graduate School of Journalism, and is the author of numerous books, essays, and articles. I can also say secondhand, but with a real sense of confidence, that he is a fabulous mentor for young lawyers, because I have the privilege of working with two young lawyers he's mentored, Ms. Ligon, the supervising attorney, and Ian Kalish, this year's First Amendment fellow. Both of them came to us from KL. So it's a great honor and privilege to have Mr. Abrams here and to introduce Nicole as well. And Nicole?
Well, Floyd, I am thrilled to have you here, as Jeff said, as I think we all are. I remember asking you questions about the First Amendment when I was a 24-year-old summer associate in your office, and now I have the pleasure of doing it in this room in front of all of these people. So not much has changed in that regard, but it's great to have you here with us. And obviously, you have a long list of accomplishments that Jeff partially read off, but it had to have begun somewhere. So I guess just to start off, as a young lawyer, how did you first start practicing First Amendment law?
Well, first, let me thank you all for coming. Thank you, Jeff and Nicole, for the introductions. We miss Nicole.
You can't have her back.
Yeah, it was a great loss, but we have to move on. Maybe I can start by saying this. I had no idea what I wanted to do or where I wanted to do it when I was in law school. I'm from New York. Certainly thought I'd go back, but I wound up as my first job working at a university. I thought perhaps going into teaching undergraduates about constitutional law, which I had undergraduate courses in at Cornell. I really had no sense of where I would or wanted even to wind up. My first job was working at Princeton with a professor who was doing a book on the office and powers of the Chief Justice of the United States. The book never got written, but it was my first real job, and I was there for 10 months or so. I then clerked for 2 years for a federal judge in Delaware and learned an enormous amount, but also got a sense that I really had learned something in law school. It is easy when one graduates and looks at a world filled, or so it seems, with lawyers, to think about all the things they know and you don't know. One thing I learned clerking, I had the sort of feeling, I could do that. I could do better than that guy, or at least as well. And then I asked the judge for whom I was clerking if he could give me a list of New York law firms that had done well in front of him, that he thought well of. And he hand wrote out a list of 5 law firms. The first, alphabetically, happened to be Cahill Gordon. And I went for an interview there. In those days, everything was much less formal than it is now. You didn't need appointments. You didn't need to send a lot of stuff in advance. Didn't need to be chosen to be interviewed. They just said, when you're in town, stop in. And I did, and they made me an offer. I thought, oh, this is a great place. And so now 56 years have passed, where I've been at the same firm. The firm had represented NBC for a number of years. And at that time, as you may have read, there were really just three networks, NBC, ABC, and CBS. There were more radio stations, but television was just really those three. And under the administration of Richard Nixon, there was great antipathy towards the press. And among other things, a lot of subpoenas started to be served on the press for confidential sources of journalists. And sometimes just to have a journalist say, I was at this event and such happened. And so the client needed legal protection, if only because of the enormous amount of time all these subpoenas were taking. Because what was happening is that particularly government lawyers, when they were trying people for certain things, particularly things which were very public, where there were press conferences, who better to subpoena than a journalist? Journalists in those days were more popular, by the way, and less beleaguered than they are today. And so we did a lot of work for NBC then, in which we were sort of making up as we went along what the First Amendment must mean. And the reason for that is that there was just so little in the way of case law. I mean, there were these great dissenting opinions. By the way, I'm not related to the Abrams, in the Abrams case, who wound up going back to Russia. So we had cases in which journalists are being called particularly for confidential sources. And there were very few cases then, and none under the First Amendment. But there were a lot of confidential sources. And so sort of reasoning from the fact that there was a First Amendment, that it protected the press, and that the journalists were telling me they couldn't do their job if they couldn't, at least in certain circumstances, promise confidentiality and mean it, or being ready to go to jail if necessary, that we started making arguments about confidential sources and why they were protected. And that was really the beginning of my involvement. I know, to be sure, I had taken courses in college, whatever Cornell offered then, about the constitutional law. I had been in national debating contests about what was then called trial by newspaper, which is sort of a pejorative way of saying that the press unfairly writes about criminal defendants in cases. And so I sort of slipped into being a First Amendment practitioner. I really believe, I hope this doesn't sound too self-serving, I may have been the first, quote, First Amendment lawyer, unquote, because the phrase wasn't around at the time I started working. And so by a process of being interested in the subject and the fortuity of being around at a time when First Amendment law started to really be developing in the late 1960s and early 1970s, that's what I came to do and be associated with. I can't say that is a model, because different things happen and different opportunities occur to different people. But it is a model in one sense. People that practice law wind up in one way or another with different sorts of opportunities, chances, engagements, involvements. It can be in lots of areas. It is in lots of areas. And of course, a lot of lawyers leave the law and go do other things, usually much better because they've been to law school. In any event, that was my beginning, and it was my good fortune that I was able to be around at the right time and to do well enough in any event that I got to do a lot of the First Amendment cases through the years.
And as a First Amendment advocate, you've represented clients from really both ends of the political spectrum. You've represented the New York Times, the Pentagon Papers case, to Senator Mitch McConnell and Citizens United. And I think that many people have been surprised by that. And your decision to represent, in particular, Senator McConnell and Citizens United. But you've stood by that decision, and you've stood by the decision in the case itself. So I guess my question to you is why? And how does representing people who have interests or beliefs that differ from yours, how has that impacted your view of the First Amendment over time?
Well, let me start with a general statement. The First Amendment is nothing unless it applies to everybody. It can't be only applicable to or usable by people with one set of political views or political engagement. Now, it is true that for a long time in American history, the people that needed the First Amendment were either radical, usually radical left, socialists during World War I, people starting labor unions in the 1930s. These were people, if one has to use the word, people of the left politically, and for the most part, through the years until 20 years ago, I'd say, the First Amendment was more needed by and used by people whose either views were of the left or who found themselves abused in the sense of being punished for their speech. And more often than not, that were people with limited money, with limited power, and who needed the protection, the shield of the First Amendment. In more recent years, a lot of the cases that have come up have been from the right, speaking again very broadly. My own view is that it's very important that the First Amendment not be applied the same to everybody, which at least in theory everyone would agree with, but that regardless of its political and often even social impact, that it has to be applied with the same vigor. So my view was in 2010 that the following case came about. A conservative group made a movie called Hillary the movie. It was documentary style. It was very harsh. It was very negative. I think it's fair to call it a hit job on Hillary Clinton. It was described by Justice Kennedy in the Citizens United case as sort of dedicated to the proposition that she should not be president. I happen to be then, and to some extent now, a supporter of hers, and certainly was at the time this documentary came out. The law that was then on the books which was known by the name of its sponsors, the McCain-Feingold law, and in law for us, the Bipartisan Campaign Finance Act, was a reform sort of law designed to try to deal in some way with the problems of money in politics. Too much money, too few people, too much power. What it did was to say that within 60 days of an election or 30 days of a primary, it was illegal for corporate money to be spent with respect to anything on television, cable, or satellite. So if there was corporate money involved, it would be a crime for the broadcaster to show this documentary. Now, the conservative group involved here wanted it to be on pay-per-view. But the entities that would, in effect, run pay-per-view would be at risk. And the broadcasters, the entities, simply wouldn't broadcast it because it would be illegal. My view was, this is political speech. What could be more in the nature of political speech than a documentary denouncing a candidate who was running for president? And then let me say, at that time, she was expected to be nominated. Now, Barack Obama wound up being nominated and elected, of course. But at that time, she was viewed as the very likely Democratic candidate. And for me, with my First Amendment background, and this was the first time I really looked at this sort of issue, for me to say that it would be a crime to broadcast a piece of advocacy of who not to vote for president, because there was corporate money involved, or the statute would include union money also, was just unacceptable, and to me still is. So it wasn't really a hard choice for me. And when Senator McConnell, who I did not know, called me and said that he'd heard that I might be on his side on this, I agreed to represent him and indeed to do it pro bono, which is what I did in two cases. One, first McConnell versus the Federal Election Commission, which was a facial challenge to this law. And then in the Citizens United case, Citizens United was the conservative organization, it's still around, that made this anti-Hillary film. So that's how I got involved in that, and that very broadly is why I'm still of the same views that I was then.
I think that raises a good point about just the pushback that you've gotten is in part because we live in a very politically polarized society today. And now more than ever, there seems to be a lot of confusion over what types of speech receives constitutional protections. Is hate speech protected? What constitutes hate speech? And I think it would be great to get some information from you and to hear what you have to say on, is hate speech protected, and why, if it is, and where do we draw that line?
Well, first, let me say that the First Amendment really is unique in the world in terms of what it does protect. There are a number of democratic countries that can make certainly they would think as good a claim as we to being a free society and the like. And those countries, for the most part, significantly limit what is referred to as hate speech. Hate speech is what it sounds like. The speech denouncing people, groups, or the like because of race, religion, sex, lots of other topics, and sometimes doing it in the most vile and potentially destructive ways. Our approach is to say, if people speak about public issues, they are protected, very broadly protected by the First Amendment. And of course, there are some things that are speech-like. Testifying falsely in court, perjury, right? No one thinks that's protected by the First Amendment. There are other speechy sort of things which are not protected. And there are some areas in which we simply provide more protection for speech, but still some limits on it. Libel. Libel in England. Our law comes from England, although to a significant degree in this area, it is varied from English law. In England, if you say something which is defamatory, which is really bad about someone else or something else, you have to be able to prove it's true. Here, because of the First Amendment, we reverse that. And the person who has spoken doesn't have to prove the truth. The person that's complaining has to prove that it was false. And in a great case that I had nothing to do with, decided in 1964, New York Times versus Sullivan, we broke from English law in the area of libel and said, when you talk about a public person, public figure, public official, you can't be found to have libeled that person unless you either know what you're saying is untrue or have serious doubts about the truth of it. So it is a subjective test, which is very, very protective as a legal test. It means you can be wrong, really wrong. And it sometimes means that there's harm affected, which is not something the law will protect you against if you're the victim of false information. But the cost-benefit analysis of the First Amendment is that it's more important to protect the speech and to protect speech generally. President Trump, when he ran for office, said things which would be deemed to be hate speech in various countries in Europe about Mexicans and about other people who he denounced. In Europe, there's case after case. Someone holds up a sign saying, go back where you came from, meaning usually people from the Middle East. That's a crime. In Canada, they had a case which I use as the first case I teach in a course I'm teaching at Yale Law School this year. The very first case I teach is a case in which Saskatchewan school system decided that they would teach about homosexuality in their high schools. And a very, I have to call him a religious zealot in Canada was not only offended by that, but printed out on literally pieces of paper, sort of old-fashioned sort of way of communicating, and put in mailboxes around Saskatchewan, a denunciation of the school system for doing that, saying you're going to teach buggery, you're going to teach fags, you're going to teach this, you're going to do that. One insult, one calumny, really, directed at gay people after another. That's a crime in Canada. The Canadian Supreme Court, by a unanimous opinion, said, even of course, we can't permit speech like this it does great harm not just to the minority that is falsely and generally accused, but to society as a whole. What do? When the Westboro Baptist Church, you may have heard about, which is like a family that self-characterizes itself as a church, they go around the country as close to churches in which dead American soldiers are being mourned as possible. The police tell them where they can stand, and they stand there, and they have signs denouncing the soldiers. And they have signs attacking gays. And they say it's God's will that this boy died or this woman died because America is too accommodating, too soft, too weak, too accepting of gay people. What does our Supreme Court do when that case gets there? The Supreme Court, by an 8-1 vote, says that this is commentary on public issues. The role of gays in American life, the role of gays in the military, religious views, all this stuff is protected by the First Amendment. Look, one doesn't have to agree with that broad reading of the First Amendment, but in particular, apropos what was said at the beginning of this session about who the sponsors of it are, more rather than less conservative group, a more rather than less liberal group. The theme of the First Amendment, as it has been applied through the years in the courts, is that we're ready to take and to inflict a lot of pain for the hopefully greater good of living in a freer society and avoiding the risks of governmental involvement in what people say, what they're allowed to say, and the like. So the First Amendment, of course, applies only to the government, but it applies just super broadly in a way that really the rest of democratic countries in Western Europe and Canada view as being unacceptably, almost thoughtlessly excessive. And our law, and it's liberals and conservatives for the most part. The Westboro Baptist Church case, think of it, 8 members of the court signing on to the proposition that outrageous, mean-spirited, harmful speech, such as what was involved there, was protected by the First Amendment because, for the most part, because we just don't trust the government to get involved in speech, thought, religious, political, etc., positions, and that's the way we live.
And Floyd, on that, as you recognize, there are harms that can flow from really offensive speech, and yet we decide that we want to protect that speech anyway. So I guess bringing it into the campus space, what benefit does accommodating controversial speakers impart on the academic environment? And why is that so important that as campuses we recognize and we respect different viewpoints, even if, and I shouldn't say respect in terms of we have to agree with them, but why do we allow for that kind of speech to be heard on campuses? And especially in a public university, why are we making sure that that's constitutionally protected?
Remember again, the First Amendment just limits the government, but just about every great university, and even ones not so great, have sort of signed on to the proposition that we agree to live under First Amendment-like rules. So, Duke, for example, could allow anyone or no one. They could ban people based on their views. They could say no Republicans, or no this, or no that. Perfectly legal. and protected by the First Amendment, in fact, if they did. But all the great schools say, they don't always mean it all the time, but they say that yeah, we're going to live by First Amendment norms, and therefore we'll open it up. Now, a university could decide, if it wanted, we're a place of scholarship. A law school could decide, if it wanted, all we want to do is train lawyers, and to say we don't want outside speakers. It's diverting, or it's not part of our educational mission. And there are some people, a minority, but there are some people scholars, who are of that view. What has happened in America is that more and more universities have become, including non-state universities, have become places where speakers are invited, often by students. And the universities, the state universities must, under the First Amendment, and private universities have chosen to say, look, if we're going to allow someone on this side, we're certainly going to allow someone on the other side, et cetera. Now that is maybe too cheery way to summarize things, because as you said, there's a darker side to this. The darker side is that some of the speakers who come are destructive in what they say. And again, the way we have chosen to deal with that is by saying, we're not going to deal with that as a problem. We're going to deal with it in terms of the issues raised, but we're not going to ban this speaker or that speaker from coming to campus. And as I say, as a legal matter, a university, a private university, could say, we don't want any speakers, or Jerry Falwell's place, Liberty University. They're certainly entitled to say, and actually they do, more or less, have policies about who they invite, being consistent with their religious as well as political norms. And, and all that is within their rights. But what the better part of our approach is that it lets students hear different views, make choices of their own, and the like. Now, that does not mean that students have to be silent. I was very admiring of members of the class at Notre Dame last year, where a significant group of black women walked out of a speech that Vice President Pence was delivering. And they walked out before he started, and they walked out quietly and silently, and the speech went on. They wanted to, and they did, send a message. Now, that action on their part was criticized by some people that I take very seriously. Fareed Zakaria on television said, what sort of generation are we bringing up? How are they going to learn anything if people are going to walk out of speeches from people that they disagree with? That's one, it seems to me, perfectly acceptable view. And in general, I think that's a correct view. I also think that people not only are allowed to, but it's not a bad thing for them to exercise their own political, social views and the like. Sometimes, you don't have to go to certain things, and you don't have to validate certain people with whom you disagree with enough. You just mustn't try to shut them up. And that's either, literally, which has happened in a number of universities with speakers, or disinvite them, which is a humiliation to the school, where the school invites some former, usually Republican member of the cabinet or something, who they then have to disinvite because they're afraid of campus unrest while the person speaks. It seems to me, look, that the First Amendment answer is, of course, the people ought to, if they're invited, they're ought to be allowed to come and speak, and invitations ought to be made by students and by universities. But the First Amendment's not going to work if we shut people up. And that is what has happened on too many campuses too often.
I'm looking at the time. Do we have
You want to
time?
ask one more question, and then we'll open it up for...
Well, I'll let Floyd actually weigh in on that. Do you have any concluding thoughts or points that you'd like to share before we open it up to Q&A?
I guess I would emphasize something I adverted to earlier. We really are on what you could think of as sort of an experiment as a country in terms of the degree to which we protect freedom of expression. I think it cannot be denied that there are speeches that lead to harm, pain, antisocial, racist. And people ought to say just that. But it's really important that the norm at universities and elsewhere, certainly at universities, places of learning, is that there's more free speech rather than less, and more openness on the part of students to listen and make up her or his mind about whether there's any sense really being expressed.
Thank you so much. Let's have well. Thank you, Greg. But in the spirit of what he's been saying, we'd like to have a chance for people to ask questions.
I don't want anyone to disagree, if you know what I mean.
Thank you so much for coming out to speak to us today. I'm curious about what your thoughts are about whether or not national security interests and the First Amendment are compatible, because we do see a number of cases where, for example, in WikiLeaks, for example, there does seem to be this tension, and in some cases, national security interests tend to necessarily, like automatically almost, win out. I'm curious, you talked about hate speech. What are your thoughts about, that tension?
Yeah, it's a very interesting and important question. Well, let me start with the easy stuff. Espionage is not free speech. Stealing secrets is not freedom of expression. That's a crime everywhere in the world, including here. That said, though, we do have competing interests with genuine claims of national security on the one hand, and genuine claims of public interest in people being free to talk about matters of national importance, which are in the national security area. I mean, the biggest case I worked on in my life was the Pentagon Papers case. So that was a case during the war in Vietnam where the top secret study was made under the direction of the Secretary of Defense to put down on paper how we got involved in the war. Now, you may think it would be a good idea to do that study before we get in the war, but that may be too much to ask. In any event, Secretary McNamara asked that a study be prepared in the middle of the war when it was going badly about how we got in there in the first place. And they became known as the Pentagon Papers case. one of their authors who had been in the Defense Department, Daniel Ellsberg, who had come to view the war in Vietnam as a war crime, leaked all but 3 volumes of the Pentagon Papers to the New York Times. The 3 volumes, incidentally, were volumes on negotiations to try to end the war. And Ellsberg did not want to do anything which could interfere with that potentiality. So the Times had these documents, top secret, labeled each one, the stamp on it, top secret, and started publishing articles. The government under President Nixon went to court to try to prevent that from happening. And a judge decided, ultimately the U.S. Supreme Court decided, that the government had not met its very heavy burden of demonstrating that publication, in the language of the critical opinion, would surely imperil the country or its people. There's an inherent problem in this area which is almost unavoidable, and that is that the government tends to exaggerate. They tend to believe it, too. They believe what they're saying, and what they're saying, time and again, has turned out to be not as dangerous as they thought. But, you have to have a body of law which governs situations like this, and our law is, right now at least, is in general very protective of the press. Now, we may have a case within the next year. Mr. Assange from WikiLeaks has been indicted under the Espionage Act. The U.S. is asking England to send him here, and if the English decide to do that, if the English courts, where it's literally being considered now, decide to send him here, we will have a major prosecution. Major in the sense that the Espionage Act is a 1919 law, 100-year-old law, which is phrased so broadly that one has to say it cannot mean what it seems to say. Publication of material relating to the national defense, unquote, provided by someone who doesn't have the right to give it to them. And what Assange has done is, in my view, a very mixed bag. WikiLeaks has done some good in some other things it's exposed. It has put at peril people in various parts of the world by exposing them to public view, people who have provided information in confidence, human rights workers and others whose names became known because WikiLeaks published them. The short answer is that conflict between claims of national security and First Amendment claims is an enduring one. It is almost a necessary one. All one can do is to hope that First Amendment overviews continue to be applied in the sense that it's really important not to interfere with journalists deciding what to print, and it's really important that the public be informed about matters of public interest. But there are some situations in which that gets really hard. Just one more line. The case I think was most telling in that respect is 1979, when a magazine published an article on how to build a hydrogen bomb. It was a magazine called the Progressive Magazine, doing it in order to warn the world about how easy it was to do so by saying how to do so. A very, very imprudent judgment, I think. But nonetheless, I mean, that's a case in which people who were in it since 1979, so people as young men and women, mostly men then, who were involved in building the atomic bomb, testified via affidavit that if this material was published, it would do great harm and imperil the security of the world. At that point, only 5 countries had hydrogen bomb, and the danger was very real. That said, it turned out that the same information had been published elsewhere, and the case was then dropped. And fortunately, but maybe luckily, nothing bad came of the publication. But the national security area undoubtedly is one which will always and require very tough examination. It can't be enough. It cannot be enough to say that there's a great risk out there. My favorite line in all of American jurisprudence is Justice Brandeis, in one of his truly great opinions, saying, men feared witches and burned women. And he went on to say, it can't be enough to say that this is a terrible danger. We can't limit or punish speeches just on that basis. We can only hope that that our administrations and our courts act reasonably.
Someone else? Yes, sir.
What do you think are the most aggressive steps that our government could take in pursuit of the goals of publicly funded elections without running afoul of the current interpretation of the First Amendment?
To me, the most important thing is to make sure everybody can vote. It has become so common in so many states to make it difficult for people to vote, people who have been in prison, people who are in prison, for example. We live under a regime of gerrymandering in which one state after another winds up arranging voting so that the party in control has to win. I mean, the case the Supreme Court decided just earlier this year, basically they said was a political question, so they wouldn't decide it. But what happened from North Carolina, no less, was that the legislature, the state legislature in North Carolina, Republican-controlled, arranged the districts so that in a state which is basically 50-50 in terms of voting, the Republicans got 10 seats in Congress and the Democrats 3 by a very sophisticated way of seeing where people lived, who voted, and the like. And when the head of the Republican Party was asked, why'd you do that? He said, because we couldn't think of any way to make it 11-2. Now that case came up from North Carolina and from Maryland, where the Democrats had acted similarly, not quite as crudely, but similarly. And the Supreme Court said wrongly, in my view, this is a political question which we're not going to get involved in. But it seems to me that the most important things that can be dealt with are making sure that people can vote and do vote and that their votes count.
One more question. Someone. Yes.
Thank you. What's the best way for universities to handle the situation where, say, a controversial speaker is invited to campus, and then because of make the event impossible? I'm thinking of Berkeley from a couple of years ago.
Yeah. Yeah.
What's the best way for the administration to handle something like that?
There is no best way. I mean, I had thought that maybe the law would be interpreted in a way in which universities, let's say state universities, therefore bound by the First Amendment, could say no to certain speakers because the costs would be so enormous. That is not the law, and indeed the law is to the contrary. Just as you set it forth, I mean, there are ways to deal with it, which I think, at least at this point, we wouldn't want to do. I mean, as long as you treat everyone the same, you can allow more or less speech, or more or fewer speakers. So, I mean, if this gets completely out of hand, universities would be free to enact rules which are even-handed, but which ultimately wind up limiting the amount of speakers or the nature of some speakers. But right now, I really don't think it's a solvable problem, and I'm really glad to have been able to add to your knowledge on that.
Thank you so much.